Fantastic.
No, I've got it here.
Yes, sir, I do. Hey, Lonzo, how you doing?
Alan, take this with you when you go. He's got the money in the form.
Look, this old guy won't spill
Let the gavel pump.
It just hang it back on my shoe. Ring lights and yeah, we're not. What is it? Okay.
Michael, put some watch.
Just one.
That's all, yes.
I just wondered. I got his seat right back here.
He showed up.
Yeah.
We'll call the meeting to order. You have a copy of the minutes, any additions or corrections? If not, need a motion to approve. Mr. Taggett?
Second.
Mr. Lyons, all in favor? Okay, it is unanimous. You have a copy of the transfers. Any questions on those? If not, I'll entertain.
Make a motion.
Second.
Mr. Hughes. Any questions? All in favor? Okay, it is unanimous. You have a copy of the bills and the hand checks. Any questions on those? Anybody? If not, need a motion to approve the bills and hand checks. Mr. Lyons?
Second.
Mr. Hoffman? All in favor?
Judge, I'm going to recuse from any Parks and Rec that may be in there, please.
We need to enter in the minutes that the clerk turned in fees of $100,404.21. And Barbara O'Hara, front and center.
Excuse me.
All right, so good to be with all of you tonight. This is my second year as library director for the wonderful Scott County Public Library, and I love to brag on our library. I have given you a handout that looks like this. It's very colorful. This is our public report, annual report. And so you could follow along with me, if you would. Libraries are books, and there's so much more. You'll see there the number of books in our collection. We're almost going to hit that magic 100,000. We're going to have a party then. Books circulated, 265,000. Card holders, we had an increase this year of 13%, so I'm very pleased about that. And over 200,000 visits. If you look at the bottom, even when our doors are closed, we're always open. And that's, our ebooks have circulated over 21,000 times, and people are catching on that they can use their Kindle and their iPad to download books free from the library. And we're trying to get that word out that people can do that with the library card. So that use of the library is up 60%. We had over 96,000 visits to our website, 2,000 plus Facebook likes. Don't forget that. If you turn it over, you see we are not just one building We are everywhere, and I'm especially proud of our outreach department. The Bookmobile had almost 3,000 visitors, 10,000 books circulated. Library Express, which is kiosks that are in Stamping Ground and in Sadieville, we have computers there. We have a place to drop books, a place to pick up books, lockers to pick up books. And we had over 1,000 books circulated that way. We had over 335 outreach programs in this past year. We have databases. Our databases were used over 47,000 times. So we're able to get all of these numbers to show how the public is actually responding and using our library. And this year we have a very exciting and interesting year ahead of us, because in November we are expanding the library building, making it bigger, and you'll see at the very bottom of this sheet, libraries are brick and mortar buildings, and ours is expanding. So we are adding almost 14,000 square feet. This was something the board prepared us for several years ago by buying the land next door to the library, and we're adding and expanding onto that land. And you have a little idea of what we're adding there. We're adding a bigger community room. Our meeting rooms are packed. We actually end up turning people away because the two meeting rooms that we have are often booked. They are free, and so they're very popular. Anybody have any questions about that? Anything you want to ask? Okay, and then the second handout that I gave you is called The Value of Your Library Services. And you'll see at the very top on the sidebar in gray that this year we have adopted a rate of real property at 5.9, personal property 6.0, which is lower than the compensating rate, and the motor vehicle 6.0. And I thought it would help you to look at the two previous years and see that the library is consistently going down in our rates. We're really cognizant of the fact that it's a difficult time economically, and so we're very conscious of what we do with taxpayer money. You'll also see on the right-hand side, you'll see a list of services, books borrowed, and the cost. Now what we do is we average the cost. This is called a library calculator, and many libraries do this. Total value, $7,666,000. Library tax collected, $2,419,000. Total savings, return on investment, 69%. Per capita tax paid. And so in other words, you're getting a huge bargain with your library, with your county library system. And the impact on the lives of the citizens, it's priceless.
Is your expansion, is that, any of that being bonded, or is it coming out of your reserves, or how
It's
you?
coming out of our reserves. For the last 14 years, the library administration and the library board have saved the money, essentially. And so it's all coming out of the reserves.
So they'll be clear and free once it's done.
Yes, yes.
With an expansion of almost 50% of your existing square footage,
Right.
do you anticipate adding to the number of volumes in circulation, or do you think other services will absorb that extra space?
We will add more volumes. The children's room will be substantially bigger. We have a huge program attendance by the children's in the community. We're making a larger Kentucky room because we are getting many donations of local history, both papers and documents, pretty valuable things, and we want to have room for them. So we're doing that. You'll be able to see the difference. And the community room that is going to take up the bulk of the space will be able to seat about 260 people when it's finished. So it will also be able to be divided into smaller rooms so that it can be used when it's not a big crowd or a big program.
Anyway, additional parking going to go with the facility?
We're still debating that right now. We know that that's important. However, our parking lot in the back where the staff parks is not always full. We are talking about putting an additional entrance in the back so that people will be encouraged to use the back parking lot. Anything else I can answer for you all? I thank you so much for listening to my presentation.
Well, Barbara, you're asking us to receive, I guess, not approve your tax rate of
Right.
.059%,
Yeah, it's 5.9.
yeah.
Yes.
Okay.
Yeah, that's the adopted one this year
Yeah.
that the board has
Do we
adopted.
need to vote on accepting it, or we're not approving it?
You're just receiving it.
Receiving it.
We need a motion that we have received the tax rate for the library.
So
Mr. Hughes,
Second.
Mr. Huff, all in favor? Thank you.
Thank you.
It's unanimous. Sharon Flynn, you're next.
I don't have a presentation. I didn't. Our new special government entity laws require that we always, well, I'm Sharon Flint from Cooperative Extension, that we present our tax rate in writing, which we do every year to the county clerk and also to the judge executive office. And then this year, it also stated that a representative from the extension office needs to be here. So as budget contact for that's why I'm here tonight. So if you all have any questions, I will do my best to try to answer those. But we have already turned in our letter of recommendation for our tax rate approval.
The rates, real property is 1.81 cents per 100, personal property 3.22 cents per 100, and motor vehicle watercraft 1.6 cents per 100. That's the
Correct.
rates that the Extension Board.
And that is compensating.
Any questions for Ms. Flynn? If not, we need a motion to receive the Cooperative Extension Service.
So moved.
Mr. Parker, any questions?
And
All in
we're
favor?
we're accepting, not approving.
We're just
Right.
receiving.
We're receiving, yes,
Yeah.
You're acknowledging the receipt of it.
yes.
All in favor? All right, thank you, Sharon.
Thank you.
And Jared, have you got the health boards?
Some-
Yes,
yeah,
the same last year, 2.2. Stacy has the minutes.
The health board decided to just leave it at the rate
Yeah.
it already had at 2.2.
Tax rate was set at .022.
Yes, sir.
Okay, we need a motion to receive the tax.
So moved.
Mr. President, all in favor? Okay.
Oh, Judge,
Did you-
can I ask Lynn, since I'm on that board, should I abstain to the vote? Judge, I will abstain from that vote since I'm on the board, please.
Get that. And now, the county tax rates, and we've been discussing this for a number of weeks, trying to have a fair tax rate and still be able to carry on the county's business. And the floor is open now for any discussion or motion on the tax rate.
Judge, you and I have talked about this quite a bit, and I've had a chance to speak with some of the other magistrates about it. And I would like to, this year on our property tax rates, I'd like to propose a slightly different way of doing this than we've done in the past. We know that House Bill 44 is very complex, and the way these rates are calculated are very complex. But I've worked with our PVA, Tim Jenkins, enough to recognize that when we have significantly different rates for the real property and the personal property, then it triggers an alternative calculation that House Bill 44 calls for. And that alternative additional calculation is where a lot of confusion and mistrust resides, I think. When that alternative calculation kicks in, we then have to look at issues like the true compensating rate versus the legal compensating rate. And it's tremendously complicated. And what I would ask the court to consider, I think the rate that's been proposed for real property at 0.67 cents per hundred valuation is an appropriate rate for real property. What I'd like to ask the court to consider is equalizing the rates between our personal property tax rates and our real property tax rates, that we make both those rates the same. And there are a variety, there's a number of different reasons for considering this approach of equalizing the numbers. Court will recall a couple of years ago when we had complicated conversations about setting these tax rates, and we invited a young man in from the Department of Local Government named Matt Freilich. And I remember Mr. Freilich's recommendation to us was that if we equalize the two rates, we wouldn't have the problem with that alternative calculation going forward. If we adopt the same rate for real property as we do for real and personal property, we will realize some less revenue this year. But I think the benefits that we can achieve by equalizing those rates outweigh the small financial cost. If we do this, it will eliminate confusion, I think, and when this alternative calculation gets triggered. It will eliminate some of the mistrust that exists with some ratepayers, some taxpayers, when they become confused about the true compensating rate versus the legal compensating rate. I think it's also important that 3 of the 6 taxing districts that are currently on the county's tax bill have almost equalized these two rates. The libraries was equalized. It's slightly different after tonight, but it's virtually equalized. Also, the health board is equalized, and the school board is equalized. I think it would be appropriate for the fiscal court to join with those other 3 taxing agencies and provide a more clear picture of the way we calculate taxes. And the final point I would make is personal property tax rate applies primarily to businesses, in particular the merchant's inventory. And I think that if we can take a step that both symbolically and in a tangible way is an improvement to our business community, that's something that we probably should do. And I don't want to stop the conversation yet, but at the appropriate time, I'm willing to make a motion, Judge, that we set both the real property rates and the personal property rates at 0.67 cents per $100 of valuation.
Thinking, you've said it well, and there's not much that I could add to it. I do support what Mr. Prather said, and we've discussed this at length to make sure that it's fair and that the county can continue on in the conservative way that we have, and that I think is appropriate. And any other comments?
I have a question.
Yeah.
And we're saying that would apply to real estate, aircraft and regular tangible, merchant's inventory, cars and boats as well?
You know, Bill, the cars and boats is a separate category that I haven't done enough homework yet on, but I do think that it's important that we equalize the 2 main categories.
Okay.
We can discuss cars and things of that nature at a later date. And Judge, one thing I failed to mention that I think both the court will recognize, and also that we owe an explanation to the public. This issue only became controversial about 2 years ago, when folks started paying attention to the alternative calculations and the difference between a true compensating rate and a legal compensating rate. But that controversy is here, and I think now that we've had time to study the issue, I think the court taking this action would be very timely. I think we're simply responding to the reality of the environment in which we work.
Thank you. And
Second. Do you have a second?
he hadn't had a motion yet, he was waiting.
I'll make that motion.
Okay.
Second.
Is there any further discussion? If not, all in favor? Vote is unanimous. Now, Bill mentioned the watercraft rate and the motor vehicles, and that, as you mentioned, Mr. Prather, is totally different. And the rate on that is 16.60 and has been, as far as I know, for the last 25 years. And we need to set the rate there. And my recommendation would be that it remains the same. It has nothing to do with
Yes.
the other two rates.
And I would go ahead and make that motion as well, Judge.
Is there a second to that?
Second.
Any discussion? All in favor? Bill, you raising your hand?
Yes, sir.
Oh, I didn't see it. Okay. It's unanimous. Have we got the school tax rate yet? We have some surplus property that's in the, my office and the treasurer's office. We need a motion to declare surplus property, 2 monitors, and I've got the serial numbers here and they're too long to read, but 2 monitors, 1 Paymaster, 1 IBM typewriter, 1 Brother typewriter, and 1 Terran hardware. And I got the serial numbers, and I don't know if I pronounced any of that correctly.
I was just wondering what a typewriter was.
That's why it's surplus.
I'll make the motion to surplus.
It's kind of cold to me.
All in favor? Okay, it is unanimous. And now we have one of the more confusing contracts with Mr. Ed Burton from Winchester is the CLEO, and that stands for the Chief Local Elected Officer for the Workforce Investment Act. And if you will, explain to us.
Judge, I appreciate the opportunity to appear before the court tonight. What you have before you is an amended interlocal cooperative agreement. Tom, how you doing? Good to see you. Which, if the Scott County Fiscal Court approves tonight, will have been approved by the 14th jurisdiction. It is on the agenda for the Woodford County Fiscal Court tonight, and Judge Wilson from Garrett County is attending that meeting. The 16th jurisdiction will be the Clark County Fiscal Court tomorrow morning. So if these jurisdictions approve this agreement, 16 of the 17 jurisdictions in the Bluegrass Workforce Investment Area will have approved the agreement. This is an amended agreement. The prior agreement, or the one that's in place right now, has been in effect and has been signed by Scott County and the other jurisdictions for approximately 2 to 3 years. And basically, this agreement sets out the procedures whereby funds that originate with the U.S. Department of Labor under the Workforce Investment Act of 1998 are distributed and spent by the states and the local jurisdictions. To give you an order of magnitude as to what we're talking about here, and I don't know what the total dollar figure is for the Commonwealth, but for the Bluegrass Workforce Investment Area, which are 17 counties, we're talking about approximately $11 million. And largely those dollars fit into one of 2 categories. They are dollars that are used to fund actual direct training programs in specific industries at the local level. And it could be an industry that wants to add a line, add a piece of equipment, offer a new product, and they need to do some additional training for their employees. And the Bluegrass Workforce Investment Board is the entity that actually takes up that proposition and makes the decision to fund that training program for a particular local industry. There may have been local industries in Scott County that have benefited from this program. I don't know the answer to that. So if there are questions about that, I will have to get back to you with regard to training programs that have occurred. The other large block of money that comes to the Bluegrass Workforce Investment area is for those employees that are employed by an industry that is downsizing, laying off, and those funds are available to the employees for retraining, for additional schooling, for helping that employee be counseled so that they can get back in the workplace as quickly as possible. The present interlocal agreement between the 17 jurisdictions, which are the 16 counties of the Bluegrass Ad and Fayette County, presently are operating under a very sparse interlocal agreement. It's about a 2 to 3 page document. And quite candidly, one of the major faults and deficiencies of that agreement is that it invests a great deal of power and authority and jurisdiction in a single individual. And that single individual is referred to as the chief local elected official. That individual is responsible for designating the grant subrecipient and or the fiscal agent, approving all appointments to the Bluegrass Workforce Investment Board, approving the budget for all of the dollars in the 17 counties, approving the plan of action and plan of work for the Bluegrass Workforce Investment area. All of those duties and responsibilities fall to the individual that is the highest ranking elected official as an officer of the Bluegrass Area Development District. And you're looking at that person. I'm the vice chair of the Bluegrass Ad, and by the prior agreement, all of those duties fall to the chief local elected officials. And it is my view and the view of other people that that's far too much power, far too much control to invest in one person. I believe that. And this amended agreement basically fires me from about 2/3 of those duties, which is appropriate, I believe. What this interlocal agreement does, it recognizes the fact that the people that really have the responsibility under this program are the county judges of the 16 counties and the mayor of Lexington. They are referred to under the federal law as chief elected officials at the local level. And it is their duty and their responsibility to invest themselves in this program, understand the program, and be involved in several of the action items that I just spoke about. What happens under this amended agreement is that there is an executive committee created of 6 county judges, not mayors. Under the federal law, the way that the federal law works is that they deem to be the elected official for the county government to be the chief elected official, not the mayor of the county seat, but rather the county judge in our counties. And it's those 6 individuals that are responsible for making the decisions that I talked about. First of all, they elect a chief local elected official. It's not an automatic appointment. Secondly, they designate who the grant recipient and fiscal agent will be. Third, they are directly involved in the appointment process of members of the Workforce Investment Board. And this agreement specifically calls for the chief elected officials at the local that I've just described and the Workforce Investment Board to work in concert and partnership. I have, between myself and Judge Wilson, the Garrett County judge, we have attended every fiscal court meeting. I just came from Harrison County tonight. Tomorrow morning I'll be at the Clark County Fiscal Court. Judge Wilson is in Woodford right now. And we believe that this agreement is a vast improvement over what we have now. If for no other reason, it basically spreads about and spreads out the authority and responsibility in terms of basic decision making. I came to this role as the vice chair of the Bluegrass Ad, and I came to the executive committee in January of this year. I was not an officer for the ad. I was not on the executive committee. I was asked to assume this role, and I knew that when I said I would, that there were many issues and many problems that needed to be addressed at the Area Development District and with regard to workforce investment issues. But I want to emphasize that this really is not a Bluegrass Ad issue. This is an issue relating to the Bluegrass workforce investment area and the duty and responsibility of the 17 participating jurisdictions to be involved and remain involved and work in concert and in partnership to do what needs to be done. Now, I would not pretend to say what the employment situation is in Scott County. I would not pretend to say that. It's not my business. I'm the mayor of Winchester. But I will tell you that since January of 2013, we have been blessed in Clark County. We have announced and or created in the neighborhood of 1,300 new jobs in Clark County. We've worked extremely hard to do job creation. But in my judgment, one of the things and one of the challenges that we now face and are confronted with is that we have to do everything within our power to create workers and to help workers and to help those workers find jobs and to help individuals who are seeking employment and who seek to improve their situation. And let me give you, and I'll close with this, Judge, and I'll answer any question, but let me give you an example of a program that we're doing in Clark County with these monies that we're particularly proud of, and it's called the One-to-One program. We have several industries in Clark County that came to us and said, we have machines, we have lines of product, we have things that we do in our plant that are specific to our plant. And we need some help in terms of finding qualified workers who can work in our plants and industries. So what we did was, with those industries' support and concurrence, they basically are sort of transferring machines and operating systems to the local vocational school. And juniors and seniors at George Rogers Clark High School are allowed to work on those machines and work with those work products with the intent that when they graduate from GRC, they will have sort of a leg up, if you will, on being able to work in that plant or work in that industry. That program is called the One-to-One program. It costs $180,000. $30,000 of that 180 is workforce investment money. The rest of it was donated locally by the Industrial Authority. The Industrial Authority put $60,000 into it, and the rest of the money was donated by local industries. That's an example of how these funds can be used, are used, and should be used. So having said that, Judge, I would appreciate the opportunity to answer any questions that you might have.
Any questions?
I have a question.
Yes, sir.
This is a very complex issue, and I've received a couple emails and spoke with a few people about it, and it's a lot of money. And some of the information that's been given to me with regards to the fiscal agent is that service can be procured and determine what is best for Scott County, not Clark or Bourbon or Woodford, but what's best for Scott County. If you've been involved with county government or keep an eye on the government or read the Herald Leader front page, you know that the Bluegrass ad went through, just like a couple of other entities, a very scathing review by the state auditor. So if these are services that can be procured, I guess my biggest question is, if we voted to accept this interlocal agreement, would there be a procurement of services, or would the board designate a fiscal agent or appoint a fiscal agent? Because if the board's just appointing a fiscal agent and it's not going out for procurement, then I'm not very comfortable with it.
I understand. In the agreement, and if we turn to section 2A with the sub-bullet, the very first sub-bullet, the language says designate a fiscal agent and grant recipient who shall be responsible for the WEF grant funds. That decision is entirely made by the local elected officials, which are the county judges. They can choose to go through a procurement process if they wish to, but I'm not going to stand here and predict what they will choose to do.
So no, this does not say that it will go out for procurement?
No, it doesn't say
Okay.
that at all. Absolutely not.
Okay.
It could, but it doesn't say that. And it's a decision that the county judges would make.
Sure.
But the advantage here is that with the present agreement, one person makes that decision. With this agreement, all of the 17 counties are part of that process.
But as was brought to my attention that, I mean, the county judges are very busy and they have other things and they can't always
Sure.
make the board meetings. I mean, I think that was part of the problem in the auditor's report, was the number of people that showed up, and you'd barely have quorum, and then all of a sudden, out of 17 counties, you have 5 people determining what the future was of funds of an organization. That's my biggest issue with it. I know it's been brought to my attention, and I'm sure you've seen the information that I've received, because I think it's gone out to every county so far. If we voted tonight to approve it, you said 16 of 17 will have approved it. Who is the 17th that has not approved it?
Fayette County.
And they are going to do, have they met yet, or did they vote to not?
They have not met and they have not voted.
Okay.
And it's my understanding that they are still reviewing the agreement, and they've made no decision as to what their plans are.
What time frame does this have to be accepted in? Because that's one thing I don't want to do is rush a vote if we have
Sure.
extended time to review the documents.
The original time frame, well, actually, there are 2 agreements or 2 documents that have to be ratified. Well, let me back up even further than that, and I really hesitate to do this because it really is getting down in the weeds, so to speak. The auditor's report was released the first or second week in March. I'm not sure which one it was. But after the auditor's report on the Bluegrass ad was released, then the Department of Workforce Investment prepared what they referred to as a corrective action plan. In other words, they took all of the 8 major findings from the APA report, and they said, now what are you going to do to fix all this? And let me also emphasize one more time, that I came to this role 2 months before that.
Right.
Okay? I want to emphasize that. Since that time, a great many things have occurred that were specifically addressed in the report. And since you raised it, I'll respond to that. One of the major issues was the Trent Boulevard property in Lexington. That property has
I
been
actually
sold.
didn't raise that issue, but
Well,
we're going into the weeds, but
We
that's where you always find the nice golf balls, is in the
well,
weeds.
I don't
So
play
let's go
golf,
there.
but so I'm told. The Trent Boulevard property has been sold. That was a major issue with regard to the neighborhood association there in the South Lexington area. The Area Development District building itself, we are acquiring that building. That was a specific item that was identified by Auditor Edlin. He was quoted as saying that he was very pleased with that. The closing on that is either going to be this week or next week. There was a major rewrite of all of the bylaws for the Bluegrass Ad. There was a committee called the Administration and Review Committee that the auditor's report was very critical of, and it was abolished. Everything will flow through the executive committee. And with regard to workforce matters, there are basically three major things that have to be done. And two of those things were supposed to have been done by July the 15th, and that date was moved out to October the 15th. And one of those two items was to revise this interlocal agreement. That was one of the two things that had to be done under the corrective action plan that Commissioner Brindley basically laid out. The other one is a memorandum of understanding between the essentially the local elected officials and the Workforce Investment Board itself. And there will be several specific issues that will need to be hammered out. That agreement, we've not started on this because the notion was that we needed to get this done. This is sort of like the Constitution, if you will, the broad parameter document. The MOU, I think, is going to be much more specific. Commissioner Brindley has agreed to personally assist in the negotiation of that next agreement, but actually this agreement and that next agreement are to be completed by October the 15th. And that would include Fayette County. Now, I don't know what Fayette County's plans are. I don't know what their intents are and what their intentions are. Judge Wilson and I have had conversations with staff with the city of Lexington, but I do not know what their intentions are. If Fayette County does not ratify this agreement, or if any of the other counties do not ratify this agreement, I can't stand before you and tell you what the effect of that is. You mentioned some of those stories in the Herald Leader. A couple of those stories related to me and the decisions that I made. And one of the things that I suggested very strongly, for which there was a story in the Herald Leader about, was that it is my view that there's a great deal about this whole area, the Workforce Investment Act of 1998, the workforce investment area in the Bluegrass region, the relationship between all parties, that in my mind is not nearly as crystal clear to me as to everybody else, and yet I was called upon to make decisions, and I had to make those decisions pretty quick.
Right.
And I made those decisions based upon what I felt was in the best interest of the overall program. But I'm not going to stand here and tell you that I know what Fayette County is going to do, or if Fayette County does something different, what the effect of that will be, or if Scott or Woodford or Clark, because those three have not approved this agreement yet. I can't honestly tell you what the effect of that is. Notwithstanding the fact that I've asked that question, what is the effect of that? And the answer that I got was less than clear. I'll just say that and let it go.
I don't mean to, I know it puts you on the spot and you're kind of the messenger.
No, I came over
you're
here.
the messenger.
I need to be on the spot.
I mean, the information I've received causes a lot of questions, a lot of doubt, and the fact of where the ad is coming out of and still being monitored and everything, I would either, one, like to put off the decision until our next meeting, or two, I'll just vote against it. And that's,
Any other questions?
I agree with David. We got a lot of these questions we got them this weekend, and this is a complex document, and these questions are pretty, I personally need more time to make an informed decision. I mean, I agree with David. I couldn't vote for it right now because I don't know enough without some more time to.
Well,
These
and
questions,
I'll tell you that this is not strictly speaking part of the duties of the mayor of Winchester. Right. But I'll spend as much time as, I'll come back for a work session, I'll come back for another meeting. I'll bring Judge Wilson, who is the chairman of the local elected officials. We can have that discussion in public with whomever present. It makes no difference to me. I think this is an important program. I think it's an important program for the region. And the reason I think it's an important program for the region is exactly what I've already said. Scott County has been blessed in terms of job creation. There's no question about it. And there's some other counties in the Bluegrass region that have been blessed. But we all have the challenge of doing everything that we can through our educational system, through our vocational schools, through our colleges and universities and our community colleges. We all have the challenge of doing everything that we can to try to get our workforce ready for the jobs that exist, not that are about to be, but exist. So this is an important program as far as I'm concerned. And I'll do whatever the court wants to do in terms of coming back, spending whatever additional time. I'll do that.
One of the arguments that I've seen opposed to this is the fact that if a small amount of attendees can end up with a lot of power if all the judges don't get together. And it's a fair argument because it does give more power if everybody's not participating. I don't know in your guidelines, I don't even know if you can do it or not, but it would seem to me if you got 17 counties that nothing can be done unless you have a certain percentage of attendees beyond what they call a normal quorum. In other words, out of 17 counties, there has to be 13 present before any action taken.
Well, under the agreement, I think a simple majority constitutes a quorum.
Yeah.
But let me point out that if this agreement is not revised and not replaced with some interlocal agreement, the present agreement
Because they'd all one person.
is one person makes all those decisions. One person designates the grant subrecipient, the fiscal agent, approves the budget, approves the appointments, does it all. And
but realistically, we know it won't stay that way. I mean,
we don't know that.
the auditor's not going to, I don't believe the auditor would allow that to continue. But my biggest question is, this interlocal agreement, has it been reviewed by the auditor's office? And to see if the way, not for legalities, but to see if the auditor's office is comfortable with the relationships between the different parties of the workforce board, the fiscal agent, who is appointed to each board, to make sure that because I don't want to be in the paper. I mean, the only reason I want to be in the paper is because my kids have done something great. And I don't want to be in a situation that we're sitting here for a year from now when there is an election for state offices and somebody's looking for something. And we end up that we find out that somebody's not comfortable with these relationships that are within this interlocal agreement. I would prefer to have an opinion from the auditor's office and maybe even from the AG's office saying, yes, we're good with it, we're kosher with it, and then I would be more than happy to vote for it.
Well, let me say that this work product right here is the direct result of a negotiating session, whatever you want to call it, direct discussion with the Commissioner of Workforce Investment, with her attorney present, and she signed off on this document.
But you and I both know that one department in the state government can say one thing and another department saying absolutely totally different thing. It'll be okay with the workforce commissioner, but then somebody else on another side of the state may say, no, that doesn't work, that doesn't stand up to our standards.
I fully appreciate what you're saying, painfully so, because there have been instances relating to the city of Winchester in recent memory in which a state agency said do A, a court said do B, and now the city of Winchester has to pay.
Right.
It's happened more than once. So I understand what you're saying, but from the standpoint of due diligence, I can tell you, and I'm not putting words in Adam's mouth. I mean, he said himself that his primary concern was with regard to the real estate transactions. He is still monitoring very closely everything that's going on. From time to time, either myself or John Wilson or the attorney that is helping us with these matters actually speak to employees within the state auditor's office. And I don't disagree with what you're saying, because one of the first things that I proposed was to actually ask the AG, before we were at this point, to assist with some of these legal matters, and that idea didn't get much traction. I can tell you that I was about the only person out there that thought that was a good idea. And one of the reasons that that was the case is that there were people associated with this program who said that was not necessary, that we've got a pretty good handle on the legal requirements and parameters of this process. I got to tell you, I've been involved in local government now for 33 years. First as city manager in Winchester and now as mayor. And I got to tell you that the Workforce Investment Act of 1998 is an unusual statute, because the things that I'm laying out here in terms of investing in one person, this authority, if you will, is found in the federal law. And on top of it, we have, and I can't remember what the acronym stands for, but this past summer, the Congress actually did a rewrite of this law, which instead of it being the Workforce Investment Act, it's the Workforce Investment and Opportunity Act or something like that. And in a time when Congress seemingly can't agree on anything, they agreed on that overwhelmingly. So in addition to the 1998 Act, we now have a new statute in place that further complicates all this. But I appreciate where you're coming from, sir. I don't, the only thing I would say to you is that my role in this is to get from where we were to where we need to be.
Right.
I think this agreement is a better agreement. I think it's a vastly better agreement than what we've got in place. But if we don't adopt anything, I disagree with you about the notion that somebody's going to come down and say the existing interlocal agreement is null and void, because if that's the case, then I have no idea, none whatsoever, how we're supposed to operate in the Bluegrass region with regard to these matters. I don't have any idea who makes the appointments to the Workforce Investment Board, who approves the budget, who does any of this. If this agreement is not adopted, and the one that's in place now is declared null and void by somebody, I think that's a very confusing set of circumstances. And I don't know where that would lead us. I honestly don't.
And that's what you just said is another reason that makes me pause to vote for it, is because if we don't do this, God knows where we're going to be. Well, there's always another option. There's always another option. I've said enough. I don't have anything
When
else
is
to
the
say.
review time after the agreement's agreed upon? When would there be a mutual agreement to review it?
Well, it's, and I assume you're the county attorney? Okay.
Yes,
Your county attorney can advise you on the process, but the effective date on page 2 of 9, section 1, it requires approval by the Department for Local Government and the Education and Workforce Development Cabinet. And there's no timeline whatsoever as to how long that may or may not take. I have no idea. I honestly don't know. I do know, and the workforce the Workforce Investment Department, Commissioner Brindley allowed us to extend this period from July 15th to October the 15th. I don't know if she would extend it again. And if it's not extended again and we missed a deadline, I don't know where that leaves us. I don't know if we can run up to the first or second week in October and we're good to go from there. I honestly don't know. I mean, we've done interlocal agreements in Winchester in which the review period for the agencies that had to review them lasted months, long periods of time. So another question I honestly don't have the answer to, and I'm not going to pretend I do.
Judge, I think with the number of questions and concerns and some of these questions that were posed to us only recently on a very difficult subject to understand for most of us. I don't know if 2 weeks is enough or if a month is enough for us to make sure Glenn's comfortable with what he needs in here, and for us to have those questions that we need to ask you all. There's no use having you come back if we're not prepared to ask the questions that we need answered. I don't know if 2 weeks or a month is the more appropriate time, but either or, I think we need to set a time, and I appreciate your offer and would take you up on it if you and Judge Wilson would both come back to answer any more questions that we may have. I don't know any other way to do it, but I'm not sure whether the court's comfortable with 2 weeks at or a little over 2 weeks, which would be our regular meeting on a Friday, and that may not be convenient, or the fourth Thursday of September.
Why don't we do this? We have a workshop the first Friday, and we can discuss where we are as everybody has a chance to look at this, and then call and set up, whether it be the next Friday or the following Thursday.
A week may not be quite enough notice to get them here, but.
I think you're talking about just us
Us
discussing.
talking to see where we are,
inviting
not
back
them.
yet.
Okay,
Yeah,
that's fine.
Yeah,
That's fine.
where the court is in our workshop. And we can discuss it at length and then decide when we want to.
And Judge, I'll make myself available. I'll make myself available. The only thing, a Friday sometimes that conflicts with grandchildren time. So, but I'll make myself available, and I'll speak for Judge Wilson. We'll
Well,
both
we
make
meet the
ourselves-
fourth Thursday in the month also, at
Right,
night.
That's what yes.
And so that's pushing it down the track a little bit.
The timeline is controlled entirely by the Scott County Fiscal Court.
Well, I know, we're trying to be cooperative.
Well, can I ask a question
Sure.
too, please? And Mayor, appreciate the fact that you'd come over from Winchester to spend your personal time and help us with this complicated issue. A couple of questions even before we go away to start whatever process that we're going to have. The explanation that you gave about the resulting board from the new interlocal agreement makes it sound like we don't have a real idea about who the fiscal agent would be. The board hadn't been appointed yet. You're not
No,
going to
we
surmise.
know that now.
That-
As a result of my decision and my designation, for ill or good, right or wrong, and I've been heavily criticized for making that decision. But that fiscal agent designation, we absolutely know who that is now.
And that is the Bluegrass Area Development
Correct.
District, is that correct? And historically, the Bluegrass Area Development District has received significant administrative funds from workforce investment program activities.
They have received, well, they are the provider of core services, which means that they are the entity that actually provides the services at the local level with regard to these programs, the one-stop centers and all that sort of thing.
So I do think it's important for our clarity
Sure.
that we not in any way disguise the fact that we already know if we enter into this interlocal agreement that we're continuing this relationship with the Bluegrass Area Development District to operate this program.
I disagree with that because we don't know. It's going to be up to that group of chief elected officials. They're the ones that's going to decide. And I don't know what they will decide to do.
And technically, to the letter of the law, Mayor, I would have to say in a debate that you would be correct. But I think we all know what that likely outcome is going to be. And it's going to be a continued relationship with the Bluegrass Area Development District.
Could very well be.
I just want us to, rather than whistle past that point, I think we need to embrace that point as a part of our consideration. I think not to do that would be a mistake on our part. And I agree with the others. I want time to carefully review this. I couldn't agree with you more, Mayor, that workforce development is one of the most important things that all of our communities face. We hear consistently from our large employers that they need more candidates. They need better trained candidates. They need better prepared candidates. And it is absolutely essential to our future. When I look at the importance of the workforce investment program, the thing that I want to evaluate going forward is where will our citizens be best served for this program, its fiscal agent, and its program agent to reside. As I've thought through some of this, I've remembered back to Governor Paul Patton's effort to separate the University of Kentucky and the community college system, which was fought tooth and nail by UK. It turns out that separating those agencies, has allowed UK to pursue its goal of being a top 20 research institution, and clearly it's benefited the Kentucky community and technical college system. I'm not sure if that analogy is entirely correct, but I appreciate your willingness to engage us in a conversation to determine what's best for our citizens.
Thank you.
Any other questions or comments? Well, I guess, Mayor, where we stand, we'll discuss it at our
Sure.
first workshop and get back with you.
Very good. And I appreciate your time
Thank
and
you.
your thoughtful discussion very much. Thank you.
We have second reading of ordinance 1403.
This will be done by summary of the ordinance amending the Georgetown Scott County subdivision and development regulations. Section 1 amends Article 3 of the subdivision and development regulation to provide that preliminary plat approvals are valid for a period of 2 years. Provides that where street or utility improvements are involved, approval of construction plans for a proposed subdivision or phase of a subdivision shall extend the preliminary plat approval an additional 2 years from the date of the construction plan approval. Provides where street or utility improvements are not involved, approval of final plat for a proposed subdivision or phase of subdivision shall extend the preliminary plat approval an additional 2 years from the date of final plat approval. Provides for an additional 1-year extension of preliminary subdivision plat approvals, provided that appreciable changes in the vicinity of the approved preliminary plat have not occurred, and that's upon application to the Director of the Planning Commission, subject to the Commission's review. Section 2 amends Article 4 of the subdivision and development regulations to provide that preliminary development plan approvals are valid for a period of 2 years. Provides for an additional 1-year extension of preliminary development plan approvals, provided that appreciable changes in the vicinity of the approved preliminary development plan have not occurred, and upon application to the Director of the Planning Commission, subject to the Commission's review. And provides that all prior ordinances or parts of ordinances in conflict with this ordinance are repealed, and it will become effective on passage and publication.
We had extensive discussion of this at the last meeting. And is there any questions? If not, I'll entertain a motion that be approved. Second reading. Is there a motion? Okay, Mr. Tackett, is there a second?
Second.
Any further discussion, or any discussion? All in favor? And opposed? Bill opposes it. Okay, thank you. We have, Jack, Resolution 1408, continuity of government.
According to KRS, and it's actually listed in the KRS, that continuity of government already exists as far as how the court is to proceed in case of the absence of the judge or the deputy judge, who would then step in. I've had discussions with Glenn about this, and this is something that is a part of our emergency operations plan. And whether or not you want to list your names in those blanks, or if you just want to list positions, I don't think it really matters as far as our agency is concerned. And I'll leave that up to our county attorney to make that decision, what's best. But we're just requesting that an updated signed copy of the continuity of government ordinance or resolution be put in place.
Do you have comments, Glenn?
I'll just read this, and it's put in a somewhat of a generic form where there is no name listed as such, and it could stay in effect for a period of time. I had one where specific names were mentioned, but that would have to be redone almost annually, if not every 4 years, maybe annually. It says, whereas the Scott County Fiscal Court deems it necessary to provide for the orderly succession of the office of Judge Executive in the event of absence or disability of the Judge Executive as defined in KRS 67-725 when involving a national, state, or local emergency. And whereas under KRS 63-190, any vacancy in the office of the Judge Executive is filled by the Governor. When a vacancy occurs, the county clerk is responsible for notifying the Governor of the vacancy under 63-210. The county Judge Executive appointed in this manner serves in accordance with Section 152 of the Kentucky State Constitution. And whereas the line of succession contained in this resolution is to ensure that a county government official is available to serve in the absence or disability of the Judge Executive, Deputy Judge Executive, or any successor. Now therefore be it resolved that when the absence or disability of the Scott County Judge Executive shall prevent him or her from serving in his/her official capacity during a national, state, or local emergency, the duties and responsibilities of the County Judge Executive shall be administered temporarily by Deputy County Judge Executive as set forth in KRS 67, 730, and 735. It's further resolved that if either the County Judge Executive or the Deputy County Judge Executive is unable to serve in the office of Judge Executive by reason of absence or disability, then the duties of the office of County Judge Executive shall be assumed temporarily by a member of the Scott County Fiscal Court as set forth in KRS 67, 710 through 67, 745. And essentially what that statute says is that it is incumbent upon the court to choose someone to serve in that capacity under a temporary basis. Under Chapter 67, as I read it, it's already defined. It's already laid out as to how the succession goes. It defines disability or absence. It defines emergency. It indicates who will assume the duties, and it also talks about the termination of that appointment would be under 67-745, and that is when the state of emergency is terminated. So it's pretty much laid out already in Chapter 67, but the resolution won't hurt anything.
I've talked to Jack and a couple of members of the court, and it seems logical to me that we name positions as opposed to people. I think right now, if something happens to me, I think Mike Wright's next in line, isn't
That's why.
Yeah, that's why we voted it.
he? So it hasn't been updated. And my recommendation, it would be that we do it by this resolution as opposed to, and we will have at least 5 and maybe 6 new people in here. And if you put new names, then you got to change them in 4 months. So,
So does the statute say if something happened to the judge and the deputy judge executive, does it say who is next? Does it lay that out?
In 67-740 said if neither the county judge executive or deputy county judge executive is able to serve in the office by reason of absence or disability, duties of the county judge executive shall be assumed temporarily by a member of the fiscal court selected for this purpose by the fiscal court.
well, you could have an emergency meeting, is what you could do.
That's what you.
I know we could have an emergency meeting, but
Somebody'd have to call it if
Yeah.
there's no judge.
Well, I think that
The court.
the court can call
everybody
it,
nominate
but
themselves one by
it's a
one.
rare thing for an emergency. And
I move we proceed with the ordinance by
Resolution,
position.
resolution.
Resolution, I'm sorry, by position rather.
Second. Any further discussion? All in favor? Okay, it's unanimous. Jared, I need to see you just a second.
Bill. And Stacy, I will bring you up the judge to sign. I've got one typo I did not see this afternoon. I'll fix that for you.
You changed it.
Is Mr. Haddix here? Oh, that's you. This is about Doe Court, and we had some questions, Mr. Haddix. and Appreciate it. Sorry you had to wait so long. Hope you enjoyed the meeting.
Appreciate the opportunity to answer your questions.
The question we had on the petition, I think there were three blanks.
There's
Oh.
two,
There was,
only two. I think you were missing, you looked at, there was one page that had 3 blanks, but there was also another page that we had another signature, so there's only 2 that was missing. It was 111 Doe Court and 102 Doe Court. I met with Brent Combs earlier today.
I talked to Brett.
And he showed me the page. He thought, oh, he's seen the one page that had 3 blanks. And then he goes, oh, I bet you had that page. But he had an additional page that had all but two signatures. And I have a verbal from one of the 2 that is missing, which was at 111 Doe Court. And he just failed to turn in his signed paper, and the remaining one, I just can't get a response out of that person. I think they travel a lot, so I have yet to get the last one, but I would appreciate maybe your consideration to move forward with taking over the road. I mean,
JR and I have been out there and looked at it, and Brent's been out and looked at it, and the road's ready to be accepted, I think, and Mr. Haddix owns most of the lots.
I do.
Yeah, so.
Yes, sir.
I would recommend that we go ahead and.
So moved.
Mr. Hughes,
Accept Doe
Mr.
Court.
Prather. I'm sorry. Any further discussion? All in favor? Okay.
Thank you very much.
You're welcome. Thank you.
Good night.
The next is a resolution for the Unified Police Protection. Glenn, you have that?
I've got the resolution. Gerald and Tony are here. You may, before I read that, maybe the court have any questions of them in terms of the actual agreement that would be deemed the interlocal between several jurisdictions. I think I sent that out to everyone on August 20th.
I think everybody has had an opportunity to see it.
I spoke with you and Tony earlier today, and I did have a little bit of concern about the protection that would be afforded the county from officers from another jurisdiction coming in if if there were a bad actor or there's some misconduct on the part of an officer from another county. You know, our officers are under our code of conduct and our disciplinary system, and I just worry about other officers not having the same level of discipline maybe that we would expect out of ours. And that was my only concern is, do we open the county up to a level of liability in that, by that agreement? I think the agreement's a great idea. I want to get it done. It just, I want to make sure we're protected, our citizens are protected.
Okay, and I understand that, and we, after we spoke with you, we went again and spoke with Chief Bossy at the police department, and who has kind of taken upon himself to spearhead this, what we all believe is a very beneficial agreement for the Central Kentucky area and all the citizens there involved, because of, again, as it's outlined in the proposal there, where we have so many things now that cross county lines, and this will benefit us all very well as far as investigation purposes. Again, the proposal thing lays out and basically restricts certain types of behavior by the agencies involved. Again, we're not, by joining on to this agreement, everybody, the agencies involved, agree that their personnel will not be just performing random acts of law enforcement in the other counties. That's not what this is set up to do. And again, it's also set up to where, you know, if this becomes an issue, the head of whatever agency is affected will contacts the other agency if there's a person involved that they're not happy with their behavior in their county or city, and they will seek to work that out amongst themselves. If that doesn't happen, then the rest of the agencies involved basically get the evidence that this agency is no longer part of this agreement. If you can't participate the way you're supposed to participate, then basically we put you out of the agreement. And as Mr. Lyons brought up earlier when he was talking to us, again, we believe that the proposal has in place the setup to cover as much as we can liability issues. It lays out the fact that any officers or deputies, whatever, involved in the agreement carry with them their powers of their authority, but also their liability from their own agencies. It's laid that out in there. Now, again, as with anything, if something did happen and we were present, something happened from either way, and somebody ended up getting sued over it, there's obviously nothing that we could put in this document that's going to keep somebody from, if they decided to, you know, suing us as well as the other people. But we do believe by the agencies signing on to this agreement and the executives of those agencies that everyone's agreeing that how the liability is taken care of. And we do believe, again, from talking to various legal people, that it would be, again, a situation where when it got to that process, it would be severed to the way it should be done as it goes down through the thing. Again, Mr. Lyons, the only thing we can tell you, and I don't know that you're really the only one that's brought that up as this process is going on, but the only thing we can do at this point is to know as much as we can the agencies that we're inviting, and then at least the initial stages of this, we've tried to keep this to a core group of people to begin with. If we have other agencies come along that want to be involved at a later process, then that's something that has to be approved by the entire group that's already a part of it. And the only thing we can do at this point is to trust in the agencies that and their executives to make sure that their people are trained and behave the way they can. You know, we have run into a situation where there have been a couple agencies that we did want to become participants in this that have brought up that kind of, maybe your people aren't as good as ours kind of thing, so we don't want to be part of it. And we're kind of hoping that that's not going to be the situation for long. The idea part of this is to aid each other, also for us to band together and improve the professionalism and the working environment of all the agencies of Central Kentucky as we go forward. So again, the best I can say to answer that, Mr. Lyons, is that we're just hoping that by the people we know that we've got involved in this, that everybody's going to perform to their level of professionalism that we can hope, and try not to sit in a position and say, we don't know that your people are as good as ours. But
Any other questions?
I don't know if it's a question, Gerald, but concern or as Sheriff Hampton's the Chief Law Enforcement Officer of Scott County, you know, it's at his request that these folks are being invited to work with you guys in those situations. I think that's the key, is that we want it to work together in situations, but this is not just if I'm driving through Scott County, I can do whatever. I'm hoping that's not the situation.
That was a big part of this discussion when Chief Bossy spearheaded this. It's not about that. It's about situations. And I'll give you an example of something that happened today. We have deputies that travel across the state daily in prisoner transports and so forth. Deputy was over in Franklin County at a stoplight, looked over, and the guy was asleep at the wheel. He got out with the guy. The car was in park, running, foot on the brake. Something obviously was the matter with him. Now, we're not going to drive past something like that. We just can't. It's not the right thing to do, and we have to deal with whatever is at hand. But having something like this interlocal agreement, we feel like is going to give us a little bit more authority and or protection being out with this person if something were to happen while we're waiting on. And what he did is he called another law enforcement agency to take care of this. But until then, he stayed there and made sure that person didn't go anywhere. So that's the best example I can give you where this is a really good thing. But as far as us going over to Bourbon County to look for something to do, no, it's not like that.
And that's my understanding, but I just want the people of Scott County to know that you know, you're the folks we're looking to for guidance on this. It's a good situation because of the many drug transactions and many investigations that you all have going on that would interact with other communities and would allow our detectives or whatever to work with those folks. I think it's a good idea. I just want everyone to know that I'm personally in favor of it, but with those restraints that you all have put in place and will be aware of, that, you know, we want it to work, but we want it to work in the fashion that it was intended to work.
Yeah, and we're completely comfortable with it. We've had several meetings with this group. I think 13 are in so far.
yes.
Several meetings, and everyone has the same concerns as you just mentioned. And we feel like that it will be controlled by each individual agency and there won't be any issues. And if there are, they will be addressed.
Again, I don't remember the exact, and I've got it with me, I could look back on it, as far as the language goes. Other than involving yourself in an investigation that is going to transpire across county lines, the only other time that an officer or deputy from another agency should be acting within the corresponding agency's jurisdiction would be in the case of an extreme and emergency type situation, that they feel that there is a threat to human life or the peace of the community, whatever, along that, if something isn't done. Again, so to speak, if it goes, you know, like you said, we're traveling. If we're on our way to Richmond for traveling and they're part of the agreement, we're in whatever, and you fall in behind a vehicle, the guy's obviously he's all over the road, he's doing a thing, dangerous to the traffic, then that would give us the opportunity or the ability to put a stop to that situation, at which time we would then contact that agency that we're in and say, this is what we've got, send me somebody out here. That's the way it's supposed to work, okay? But it does give us the authority. We could kind of do that anyway, but you would almost have to ask ahead of time, you know. This way, one of our people, somebody, they can put a stop to the emergent situation and then call us and say, this is what we're doing. I need some help.
Bill, do you have a question?
Yeah. Did I not read in here somewhere, we had a good bit of paperwork to read here lately, but typically, if someone's coming to Scott County, you would be notified first if they're gonna be on an investigation or something that's planned.
correct.
But if they stumble on an emergency like the deal in Franklin County, that gives you a little bit more flexibility in how to handle that and more support from the county that you're in. But other than that, like I said, you'll know if they're coming here, they'll know if you're going there for other investigations.
Absolutely, that's
Yes,
a
sir.
part of the agreement.
Any other questions?
I move approval of this.
Well, we haven't read it yet.
Okay, well, let's read it.
Thank you.
Go ahead.
This is resolution number 14-09. A resolution approving an interlocal agreement creating the Bluegrass and Central Kentucky Unified Police Protection System and authorizing the judge executive to sign all relevant documents, Whereas the Scott County Fiscal Court has considered an interlocal agreement creating the Bluegrass and Central Kentucky Unified Police Protection System. Whereas 65.240 requires the authorization to be memorialized by ordinance or resolution. Now therefore be it resolved by the Scott County Fiscal Court that Section 1, the interlocal agreement creating the Bluegrass and Central Kentucky Unified Police Protection System is hereby approved. Section 2, that the county judge executive is authorized to execute the interlocal agreement and any relevant documents on behalf of the county.
You ready?
So moved.
Thanks.
Can I ask one question? Do the coroners fall into this at all? Because I know their power is pretty great.
No, this is, the law enforcement agencies are specified, and it is
Okay.
just law enforcement agencies.
So I was just thinking the power that they do have, if there would be any kind of conflict on their part of it, I don't guess.
They would have to do, I would say the coroners would have to do what we did and come together as a
Okay, good.
group, and,
Curiosity,
yeah.
All in favor? It's unanimous. One more resolution. The state on the bridge that we're going to put in on Race Fork Road has a resolution authorizing, if it's passed, for me to sign, that they will fund in an amount not to exceed $88,000 for the above-mentioned project, which is the Race Fork Dam. And I'll get Glenn to read that resolution, please.
This is a resolution adopting and approving the execution of a rural secondary program agreement between the Fiscal Court and the Commonwealth of Kentucky Transportation Cabinet, Department of Rural and Municipal Aid, and accepting all roads and streets referred to therein as being a part of the county road system. Be it resolved by the Fiscal Court that Fiscal Court does hereby certify that all roads and streets referred to in said agreement are county roads as defined in KRS 178.0101 sub B. And the Fiscal Court does hereby ratify and adopt all statements, representations, warranties, covenants, and agreements contained in said agreement, and does hereby accept said agreement, and by such acceptance agrees to all the terms and conditions therein stated. And the county judge executive of the county is hereby authorized and directed to sign said agreement as set forth on behalf of the Fiscal Court of Scott County. And the county clerk of Scott County is hereby authorized and directed to certify thereto. Second page is just the vote taken on the resolution.
Need a motion. Mr. Hughes. Is there a second?
Second.
You got that? Mr. Livingston. Any questions? All in favor? Okay. It is unanimous. David.
Thank you, Judge. I had submitted to Stacy to put on the agenda for new hires when we interviewed last week, so that's why I didn't have names until the end of the week. I'd like to do the part-time first. And these are all EMTs at $12.50 an hour. Tommy, T-O-M-M-I-E, Coleman. Jessica Derringer, D-E-A-R-I-N-G-E-R. And John Wenzler, W-E-N-Z-L-E-R. They'll be part-time.
Need a motion to that effect. Okay. Mr. Parker, any questions? All in favor? Okay, it is unanimous.
And I had submitted for a full-time paramedic, but I'd like to request 2 full-time paramedics. I've actually got 2 positions that have been perpetually short. I've got several off on workman's comp right now. I need some paramedics to be on the street full-time. So I request that we hire 2 paramedics with benefits.
Have you got the names, Dave?
Yes, sir.
Okay, what are the names?
The first one is Amber, A-M-B-E-R, Lynn, L-Y-N-N. She would be at the starting rate of $10.97. She has a pediatric and a trauma certification. And that would be the first.
And let me mention before go on to the second one. He's short several because of workers' comp, and some of them have been out for maybe as much as a year. And that's created a vacant position, but it also, where we have part-time people they can only work 100 hours a month, or else we have to start paying retirement. And whether the people are coming back or not, it's an issue, and it's gonna be a bigger issue. You know, they may not come back, or they may come back, but been off for a year, or close to a year. And before we, does the court have any problem with going ahead and adding this second one?
And I'm trying to hold the overtime down also on the full-time folks too, so.
Sounds like
we've
we
had a lot of
should, absolutely should do it.
For overtime.
Okay. Does anybody have a problem with that? Okay, go ahead and give us the other name.
Mark Peterson, Peterson, at the rate of $10.88. He has the pediatric certification.
Motion to approve.
Who made the motion, John? Is second, Brendan? Any questions? All in favor? Okay, it is unanimous.
And I'll get Jane the paperwork in the morning on those.
Okay. And then,
The
You've
second
got-
thing is basically some wording on, we have an internal policy on drug testing that's already in place for the employees, and I had given Glenn the document to add students into that language, that because we have controlled substances at the service, that the students are subject to the drug testing policy that the county has. If we were to come up short on some medication or have reasonable suspicion that we had an intoxicated or impaired individual that was a student. Primarily the legacy students that are under our control, that are provided to the county.
how many students you have now, David?
We have 11 in the program.
Yeah,
I've read over the changes that he's requested as kind of a cleanup item in terms of the standard operating procedure, as I understand it. David, you may correct me if I'm wrong.
It's on our internal SOPs, and it still would follow the language that's in the administrative code of the county.
This would be prospective, in effect, and David would require the parents of all of the legacy students to sign off on it as well, so.
We have a form that has the student and administrative staff and the parent's signature on this form that stays with the packet of paperwork.
Any questions for David?
Good, thank you.
Who made that motion?
I'll make it.
Second, is there a second? That's two down. Any questions? All in favor? Okay, it's unanimous. Thank you, David. Mike?
Leslie, members of the court. Speaking of the comp issue, we have in the past, we've got 2 guys off now on comp. We're only gonna try to make one move now, because the other one should be coming up in about a week and a half to see where he stands. We've had 1 guy off for a while. He's had surgery. He's still gonna be off for a while. He had some vertebrae fused. In the past, we promote off a list, and when we hire off a list. So we have lists in place. If something happens to an officer, we lose one, we just go to the next person on the list. In the past, we've moved up people interim or temporarily, does a couple things for us. One, it gets them in the spot, lets them start working as an officer, gets them ideas what's going on. And then if something happens that somebody can't come back, you know, they've already got some training, they're in the role, and we can go on and just move them up. And that's what I'm asking here, is that we promote or move up, in the interim position, firefighter John Riddle to ride the lieutenant spot at half the raise, which is 30 cents. The normal raise from firefighter lieutenant is 60. We give them half the raise.
That's a policy that we've done in the past.
We've done that on several occasions.
Motion approved.
Mr. Parker, any questions? All in favor? Okay, it's
And
unanimous.
I got a couple other quick things, if
Go
we
ahead.
could. I had talked with you all about a month ago now, it's been about that long, I guess, with the contract for our breathing air compressor. When I got back and looked over it again, it did have some of the same wording in it that we had taken out before, so I got with Glenn, or got him the contracts. They have removed that. The only difference is there's a small charge, I believe maybe 20 or 30 bucks. It was $1,120 last year or something like that. It's $1,145 for this year. And the year-to-year automatic acceptance has been taken out of it, or where we automatically, they had slipped that back in there, but that's gone. So we have to renew it every year. I think Glenn said he thought it was okay to go on and accept that.
Guys, Mike's right, $35 increase to $1,145 for the entire contract year. And they have put a term in here. They did not do that before. They had this automatic renewal unless we terminate. I've suggested to Mike just put a little tickler in his computer system to kind of remind him to look at this on June 1st, because it has a termination date of July 31st, 2015. It may be that this is going to be one of those things you'll approve anyway, but at a minimum, I think that the agreement as it stands now is fine.
And if I could, I'd get you over.
That's contracted.
Yes.
Yeah, it's-
Authorization, me to sign. Mr.
Motion
Hughes?
Approved.
Mr. Prather? All in favor?
You had the original, Mike.
Yeah, it's unanimous.
Let me make sure. I've got the one that's still got the 30 days in it. I don't know if I've got the other one. They were gonna email it to me, I might have it.
Just bring it back
I'll
up.
get it to you. The last thing is, Honey's requesting out-of-town travel. I can tell it's her typing. She types better than Jim. She always gets to go to the best places. I think this year it's Myrtle Beach. I'm telling you, that dog is doing okay. But anyway, Myrtle Beach in October the 13th through the 17th. That's for her annual certification and to keep her accreditation as the arson or the accelerant detective dog. So we need to get, if I could, get approval for Jim and Honey to go to Myrtle Beach this year for recertification.
Who wants to make that motion?
Let me make it. I didn't get a vacation this year.
Is there a second? Second. John T., any questions? All in favor?
Tell you that dog's got it made. Thank you.
And the next jail hires, Larry's not here, but he had a subtraction of a full-time Amber Wagers, and he wants to replace her with LaDonna Baltimore at $10.75 an hour, and one part-time deputy, Eric Wiley, at $10.50 per hour. Want them separate or together?
Move both.
All right. Is there a second? Second. Any questions? All in favor? Okay, moving right along. It's unanimous.
Did you want to come up twice?
No. I'm requesting approval for Judge Lesby to sign an animal disaster response plan. This is a plan that we have been working on as an agency for years now. We've had several meetings and met with a lot of the different individuals that are involved in the animal community as far as veterinarians and animal control and so forth. The Robert Stafford Act, Disaster Act, is something that governs how FEMA operates when they come into a state and into a local jurisdiction. Part of that, there's a different act that's become part of that, and that's the Pets Evacuation and Transportation Standards Act. That is wanting local communities to have a plan, and then that plan can be reviewed by FEMA when they come in. But this plan is, like I said, has been looked at by several different individuals. The judge has a sign sheet that shows all the different players that have looked at it and have already approved it if it's approved by the court. Right now, as far as the folks that are still responsible has not changed. The pet owner is still responsible for their pet. The livestock owner is still responsible for their animals. And then Fish and Wildlife is still responsible for public animals. So Nothing has really changed as far as that goes. Basically, what this is puts everything that's been discussed into a plan. And so the saying that says, if you fail to plan, then you plan to fail. And that's something that we're trying to do, is get everything ready in case something happens. So we've got a plan to put in place and use our best foot forward.
I've read the document. I think I sent that to everyone as well, did I not? Looked at the July. Jack and I have talked about it briefly on a couple of occasions. There are areas that the county would be responsible for certain obligations and duties and expenses. As Jack's pointed out, from a practical standpoint, that may be the same thing you're going to have anyway. But you know, as far as the document itself, I don't have any issue with how it's been drafted. It's just, is the court comfortable with the mandates in here as far as the animal control and Scott County is concerned?
You've had a copy of it for several weeks now, and do you have any questions? Any objections? If not, I'll entertain a motion. We approve. Mr. Livingston, Mr. Lyons, any questions? All in favor? Okay. Unanimous.
Thank you.
I'll sign it later. What's today, 26, isn't it? Last week, or last meeting, we had Charlene Revel that came by and talked about the Actors Playhouse, and they were not asking for money. Guess what? They're asking for some funds. And it seems to me, and it is a good thing, that they're comparable to our community theater. They are a C3 tax exempt according to their report. We give to the community theater $640, and that's what they didn't, in the letter they sent, they didn't put down an amount, but that would be what I would recommend. If the court agrees, is that a motion?
Yes.
Mr. Prather, second. Any questions?
A comment, Judge. Possibly we should consider something going forward that we had a request from a couple other entities, that the time to get those requests in is at budget time. And maybe we close these things off, and that way during budget negotiations we can answer these more in a more timely manner and take into consideration other similar organizations. I have no opposition to this one, but I think it's something going forward that it's something we need to look at as far as is not having this as an ongoing throughout the entire year.
Well, I agree, totally agree with you. We had that just the last meeting. Mm-hmm. Any further discussion? All in favor? Okay. And the last item on the agenda is the Connector Road update. And JR and I were out there today.
Judge, I'm going to recuse myself just because the company...
Well, we're just going to discuss it now unless you...
Okay, nothing,
yeah.
Okay.
Yeah.
All right.
We got some pictures of where we were out there.
I can't look at the picture.
No.
You don't have to pull up on the picture.
Did we pay the air conditioner bill?
Jared's in charge of air conditioning.
Get that button on thermostat.
Who's this guy in the picture?
While passing the pictures along, one of the things, when the bids went out, they were for lime stabilization. And that has to have a certain temperature in order to be effective. I talked to the engineer today who talked to the contractor, And where we stand, if we put the lime stabilization down, unless the weather would be perfect. If everything works perfect, he thinks that he could be through by December the 1st. The engineer said he thought that was impossible. The contractor thought it was improbable because you're going to have weather issues. The lime stabilization, as I understand it from our discussion, the temperature has to be above 40 degrees, I think he said, JR, for a period of time. And when you get into November, putting that down, it's highly unlikely. And you're going to have rain days, I guess, in between. They're making great progress out there now. Which brings us up to the maintenance building, which is on the end next to the bypass. What we can do, if the court agrees, is to, for 544 feet, we can pay extra and put rock down and be able to move forward with the maintenance building. But the addition is $43,783.06. That's the difference between the lime stabilization and stone. If they have to stop work, then we're talking sometime in the spring before they can move forward, which would be April or May. And that's, if we put stone down all the way across, it would cost about $200,000, which, or more. It's $189,717 to make the base all stone. Plus, they've already got a contract with the lime stabilization people. And if there's a buyout in the contract, that would be added to it. And we discussed this right up till almost 5 o'clock, trying to get some prices.
Judge, isn't there a possibility that we could simply put a construction road in?
Well, JR and I talked about that, and maybe there is, it would be up to the contractor. They've started on the other end.
Right.
Now, they've agreed, if we go ahead with this, that they'll move to the bypass end. But if we put just a road to get in there and do the work, they would have to, we've got a contract for them to build a road. We can't tell them how to build it.
No, but yeah, I'm saying
we were going to talk to them in the morning.
A lesser cost than $43,000 would be simply a construction road to get traffic into that site. And maybe, I know what happens in other highway projects, you actually take up that material at such time.
Well, all of this came up today.
Right.
So, and we went, that would be a great scenario. Mm-hmm. Can't guarantee that. And if you've been out there, if they're willing to stop work on the west side and move to the east side, mm-hmm. and would do that, that's a possibility. I have no idea whether they are. And we were going out in the morning and talked to them. Chuck, you have a question?
Yes, comment. If we did put in a construction entrance, they're not necessarily building the road from that entrance to where the new buildings will be. That'll be built by somebody else or our road department, correct?
Well, what you've got, if you've been out there.
Well, I have been.
Yeah.
And
You
I
got
see what's going on every day. I go by it every day.
Well, on the east end is, it's about 10 or 15 feet up. Right. And that dirt's got to all be moved, and that's their responsibility to make the road level. So that's not something we can do.
Right.
Or should do.
I know they did that at the Elkhorn Crossing School. They had a temporary in there for a while or whatnot. I saw that when it took place, and then they did away when it was finished.
If
it
the,
was all taken care of.
if the contractor will do it.
Right.
Right.
And that's what we're going to talk to him about tomorrow. But if he says, I can't do that, it costs me money, then.
And you're saying it costs how much to put temporary or an entrance in? Just
put-
like number 2 rock or something like that.
Well, that's number 2
I know
rock
what
and a
you're
base
saying.
coat.
Right.
$43,783.06.
Times of
And the road
essence to
project
do
came
it.
in.
Well, but the,
That's the lime stabilization for that amount of road, isn't it?
Right.
That's for the, that would be an additional cost to get to the entrance.
I understand. And then the actual bid came in of, what, 300,000 plus under what we estimated to start with?
Under what the architect, or the engineer estimated.
I think they estimated 2 million and what, 1,000,007?
Well, it was
You know,
$1,004,000 something, and then they,
it's tough to make a decision because we're unsure as to whether or not the contractor is willing to move
Right.
that in.
the contractor will do this for $43,783.06.
But it's
Now,
not-
if you're talking about a temporary road and going in, what?
I said, they'll move. $43,000.
Well, they're not
But
anxious
at
to
the-
do it.
yeah. At the same time, if we don't do something like this, that means the project that was supposed to break ground before December will not break ground until next spring or next year sometime.
Probable, but not a
And
given.
I-
Only thing
I
we
don't
do
think
is
we
like
wanted that
we've
to happen.
done before, which we did the last meeting we had, is if we agree upon it, give the judge authorization when he and JR are satisfied with getting it done, because they're gonna have numerous meetings, just give them the power to do it.
No, I want to vote, that you want to spend 43,000, not,
Well, I'm
Yeah.
agree with that if everything works out. I mean, you know, if it's
well,
43
it'll
or.
work out if we agree to it. He's agreed to do that.
I'm a little confused as they will change and move over there to do that
Yes.
section of excavation.
That's what they said, didn't it, JR?
Then they would put down, you know, the entire length of the project is how long, JR?
3,000, just a little over 3,000 foot.
3,000 feet.
Judge, my question is, wouldn't they still have to do this, the very same thing, to build their road, if they did it all at the same time and carried through as they're going through now? This rock would still have to be there if they were on.
Not with the
no matter
lime
what.
stabilization.
No, they'd have lime stabilization.
Well, I understand that, I do know that, but still, I'm not confused, but
Well,
go ahead, I understand.
the reason that the job, and they bid it according to the specs, that's what the specs call for lime stabilization. If they'd have called for rock all the way across, then the bid would have been up to the 2.8 million, according to them, or 1.8 million. No.
And what I'm thinking about is, I watched them do the S-curve project, it's the same group doing it.
Yeah.
Of course, they didn't have lime stabilization there and whatnot, they just.
And it costs more. Yeah, it's what you want to pay for. And that, they're
You're talking about 500 and some feet? Is it,
544 feet, I believe it is.
with them, if they move to that end, you would think they could get 540 feet of lime stabilization done with 4-degree weather, but
I think they're gonna.
Well, they got to do it all at once.
they have to do it all at one time.
Yeah. They can't, they subcontract that out. And the ground has to be prepared. You can't get on it after it's prepared. You can't get on it until it settles. So,
I think, I know a little bit about the lime stabilization. A concern I have a little bit about it is because you wouldn't be able to get on it for a number of days, and it's somewhere 4 to 7 days.
I think it's a little longer than that.
Yeah, especially with the heavy traffic that we're gonna be having coming in to that site up there. It may be better to put the stone down and not worry about tearing up the lime stabilization with the heavy equipment that'll be moving in and out of there.
So if we chose to pay the additional 43,000 and put down rock for the 544 feet, then their plan would be on the balance of the road to do lime stabilization?
Yeah, according to their estimate here, rock is about 5 times as expensive as lime stabilization. They deducted for these 544 feet $11,216. They added $55,000 for the rock. And so the net is $43,000. So it's roughly 5 times as much. And the guy said he made a mistake in figuring that it should have been higher than that, but he would stand by that.
If time were not an issue, is the lime stabilization as good as the rock?
That's what he's saying.
Yes, according to.
According to them.
They're equal.
But different projects use different ones. For instance, the project on the new part of the bypass, they did Long Lake Pike with rock. I'm not sure what they did the bypass itself with either, I'm pretty sure it's rock, but, you know, they still use both mechanisms to do it. So it's not that one is absolutely better. Obviously, gravel and stone are more expensive.
So using the rock shortens the amount of time involved. We get an equally good road, but we save time. So
There's a probability, Tom, but not a guarantee that it would be next spring. That's the bottom line. They said, this is the contractor, at the best case scenario, weather and everything, that they could finish the road. What they say, 1st of December, JR? Yeah, that's the best case scenario.
But it's unlikely.
That's the best case scenario. Yeah, well, you know what November's like. And that's when they would be doing this. That's the last thing before they put the blacktop down.
So the question is the time worth the money?
That's exactly right. That's the question.
One more comment. I would think that they would have some rock off of that site, because I've seen what they're doing, that they could actually move to the other end and bring the 15 foot up. I know they did it on the project on 460.
Well, we can go out and negotiate with them again, if you want to do that and tell them, but.
I have seen that done.
You know, there's a lot of things. What is the pleasure of the court? That's the question. I can go out and ask them if they can bring rock up or start at the other end or whatever you want. But this is where we are right now. And,
I think
you know,
we
we
should give you the authorization to do the amount that they're asking, but if you can negotiate less, what Chuck is talking about, then, you know, that definitely will help us. But moving along with the project is the biggest thing.
I'm open for a motion.
I'll make the motion, Judge.
State it just like you want it.
That we give you the authority to enter into the agreement and let you negotiate.
For the agreement of how, for $43,700.
43, and
6 cents.
And then if you get it done less than that, great.
Any further discussion? Call the roll. Start with me if you want to.
George?
Yes.
Stewart?
Yes.
Alvin?
Yes.
Chuck?
Yes.
Bill?
Yes.
John T?
Yes.
Tom?
Yes.
David?
I'm going to abstain because my agency does business with the contractor.
Yeah, we told you there wasn't gonna be a vote.
Yes. Dastardly.
Jared, you did a good job on the air conditioner. I don't know what took you so long.
Recuse or abstain?
I abstained.
Okay, you vote majority, yeah.
That is all the items that I have on the agenda. Does anyone have anything to bring before the court?
I do just real quick.
Take your time.
I just needed to, we got this completed in the last day or so, the 2013 tax settlement for the county. And I just wanted to get that added in to the minutes so we can move forward with our getting
You wanna
prepared
read the numbers?
to collect taxes. Yeah, and this is all pending the state audit. This is results from the state revenue audit, and then next week we're having the audit from the state auditor's office. But this is what they've got so far. Total charges $2,695,603.08. Total credits, $94,003.84. Amount due the county, let's look the difference in what we have come from so far, $1,565.29. That's for the county. There's also, if you want to go through all of them, the school board, the health board, library. I think you want me to read all of those off? Yes, ma'am. School board charges $18,078,123.90. Credits, $612,004.42, and a difference still owed the school of $1,080.06. The health department total charge is $853,315.85. Total credits, $28,815.42, and a difference still owed to the health department, $669.50. For the library, total charges, $2,330,032.29. Total credits, $79,091.07. For difference still owed the library, $813.97. And finally, the county extension office, total charges, $724,997.15. Total credits, $25,200.23. And a total still due the extension office of $322.18. And once the state audit is complete, we will issue the checks for those, which will zero out the tax settlement for the county.
Need a motion to accept the sheriff's report.
I move.
You,
Second.
all in favor? Unanimous.
We need some copies of this.
We need a copy. You did good, Gerald. Anyone else? Mr. Livingston.
I just would like to thank you all for moving the meeting to Tuesday night so that I could be present.
You're welcome. Mr. Prather.
I've probably said enough tonight, John Pius.
Stop.
No.
Mr. Parker.
Just wanted to let everybody know that the Finley 5K is Saturday at 6 o'clock, and it's for sudden infant death syndrome. Because
Your road.
No, sir. Stacy. Being no further business, Mr. Anderson.
Rogers Gap Road.